Good morning, everyone. I'd like to welcome you on behalf of TNI, SOMO, both ends, CEO, Ecologistas en Acción, and Friends of the Earth Europe for this conference on the Multilateral Investment Court. I would like to present briefly a broader setting that this debate is taking place today. And I would say the conference on this conference on the MIC couldn't come at a better time, because only a week ago the Commission launched its draft mandate for a proposal for the MIC. About 3 years ago, Friends of the Earth Europe, together with BEUC and Arbeiterkammer, organized a big conference on ISDS. And this was in the early stages of the TTIP negotiations. And I think outside Brussels, most people hadn't even heard about the CETA agreement that was almost finished by then. ISDS at that point just started to become a hot topic. I would think that since then a lot has changed, not only on trade issues, but especially on investment protection issues. First of all, ISDS became the spearhead of one of the biggest public campaigns of the last decennia, the Stop TTIP and Stop CETA campaign. Hundreds of thousands of people took the street, and millions of people signed a petition against TTIP, actually demanding the abolishment of ISDS. But also politicians in many countries became aware of the grave injustice of a biased and intransparent system of VIP rights for investors without any obligations, allowing investors to undermine public policies. Political groupings in the EP, but also national governments in countries like Slovenia, Austria, Germany, France, started to question ISDS. Sharp criticism was also voiced from legal experts and even from the European Association of Judges, who questioned the independence of current investment protection schemes and if these schemes are actually in line with EU law. Developing countries also started to voice their concerns. Some cancelled existing BITs, bilateral investment treaties, because of the negative experience they had with ISDS. Others decided not to include ISDS in trade agreements anymore. At some point in the debate, ISDS, old-style ISDS, became a no-go. And even Commissioner Malmström acknowledged that at the beginning of this year, when there was a stakeholder meeting on the MIC, where she basically indicated clearly that old-style ISDS is dead. Since then, a couple of important things also still happened. At the end of 2015, the Commission, in following up on that, came with a proposal for an investment court system, which is included in the CETA agreement and the EU-Vietnam agreement. And building on that, they have now launched negotiations on the Multilateral Investment Court. What is still also relevant, I think, is the Singapore agreement, which came just before the European Court of Justice opinion on the Singapore agreement just before the summer. And as a consequence of that, the Commission decided recently to take investment protection out of new negotiations on trade agreements with Australia and New Zealand. And of course, a couple of weeks ago, the Belgian government went to the European Court of Justice to ask for an opinion on the legality of the ICS system included in CETA. I don't want to go now into the arguments pro or con the MIC. I will leave that up to the speakers and to the audience itself. But I want to present one more important setting that cannot be ignored at this debate. I've been involved for the last 10 years in the European debate on corporate social responsibility. And I have to say that this was quite a frustrating debate, because the Commission hardly delivered anything that is helpful for normal citizens inside and outside Europe who could become victim of corporate abuses. For more than 10 years, the Commission refused to pay attention to the problems of these victims, and they were unwilling to speak about binding obligations for investors. Instead, the Commission organized and supported award ceremonies for socially responsible companies. Against that setting, the Commission was taken by surprise when summer 2014, the United Nations decided to start negotiations on a binding treaty on business and human rights. Such a treaty should actually provide access to justice for people who are victims of large-scale pollution from mining and extractive industries, people whose human rights are violated, are victims of land grabs of large food multinationals. Such a treaty should also put binding obligations on investors. The Commission was not only taken by surprise, they even voted in 2014 against the start of the negotiations. And for 2 years, they boycotted the negotiations, Commission and Member States, I have to say. Only this year, Member States and Commission started to play ball. Next month, at the end of October, we will see the first real negotiation round on a UN treaty. The debate we hold today cannot be seen in isolation from that debate, because it is no longer acceptable for citizens in Europe and outside Europe that the EU continues to do its utmost to advance rights for investors and does nothing to find solutions for the rights of those who are actually victims of those investors. Or I would say it even stronger, we believe that human rights actually should supersede or should have primacy over investor rights. Thank you for coming to this debate, and I hope we will have a fruitful discussion.
So now it's up to me. Good morning, everyone. My name is Daniela Vincenti, and I'm the editor-in-chief of Euractiv.com. For those who don't know it, it's the online media, the leading online media on EU affairs, and we're present in 12 countries, and we publish in 12 languages. Without further ado, thank you, Paul, for this introduction. I'm going to present a little bit the panel. And for this, as you know, this morning we're going to have two discussions. One is on the pros and cons of a Multilateral Investment Court, the MIC, and a second panel on the alternatives to a MIC. So on the alternatives, we have guests coming from other parts of the world that faced problems and tried to find a different solution than the MIC. But to start off, we want to sort of go wide and deep on what this proposal is all about, now that we have the mandate, as Paul mentioned. This is a proposal that started to come into the books precisely on the corpse, if I can call it like that, of the ISDS in Europe. And the Commission came up with this proposal in 2015. What is it exactly? It is a permanent international body that can settle disputes between investors and states. It replaces the ISDS, and it has a rationale behind. I mean, from a journalistic point of view, Europe is the largest exporter and importer of foreign direct investment. That means, at the moment, we needed to find a solution, as we have currently an international patchwork of rules in the form of 2,350 bilateral investment treaties, the BITs, and over 300 treaties with investment protection, the TIPS. Besides that, we have 1,200 treaties, and maybe you're going to confirm that, yes or no, but 1,200 treaties that involve EU countries contain ISDS mechanism to settle disputes. So to put a little bit of order, that's the proposal of coming up with this court that consists of two tribunals, one first instance tribunal and an appeal tribunal. This would enable parties to appeal against the decisions of the first instance tribunal with which they disagree. So instead of arbitrators, we're going to have highly qualified judges. So is this the right decision or not? Some countries are prepared to join, some others are very reluctant. The USA and Japan did not seem very keen. Also, is there really any other solution to that? Without further ado, I'm going to present our panelists. We have on my right Nele Eichhorn, who is member of the Trade Commissioner Malmström cabinet. We have, I'm mixing up my papers, Pia Eberhard on my left, who is a researcher and campaigner with Brussels-based lobby watchdog Corporate Europe Observatory. Peter Schneiderhan, who is a board member of the German Association of Judges and works as a senior prosecutor at the prosecution office in Stuttgart. And then Guus van Harten, who is a law professor at York University in Toronto, Canada, who specializes in international trade law and has been very, very vocal over the past year on ISDS and now on the MIC. So let's start with all of you. In 1 minute time, I would like to ask you, if you could decide today on the MIC proposal, what would you decide? Let's go ahead or not? Let's take it forward or not? How would you decide and why? And I would like to start with Guus, since you are the specialist about it. 1 minute each. I'll ask you to be very, not to ask me to stop you, because we want this to be a lively debate, and we'll move on from question to question. Guus, please.
Thank you very much, Daniela. And I won't say too many thank yous because I don't want to use up my 1 minute. Okay. Investment treaty arbitration, more commonly known as ISDS now, is deeply flawed. It is not balanced, it is not judicially independent, it is not procedurally fair, and it is not sufficiently respectful of domestic institutions, including domestic courts. It should be eliminated, abolished, or replaced with something that does meet these 4 criteria of balance, independence, fairness, and respect for domestic institutions. And the MIC, or MIC, is an opportunity to do that. It's very uncertain because the proposal is vague at this stage. The devil is always in the details. But with those qualifications, I support the idea in principle. Yet I have thus far not seen much to indicate that the 4 criteria I mentioned are being accepted by the main proponents of the MIC. For example, there is reason to doubt the credibility of the proposal in light of the limitations of the investment court system, ICS, that was introduced into the CETA and other agreements. So for that reason, I am also quite skeptical.
Yeah. Well, I would not pursue the project further because I think that it cements a system that is against the public interest in Europe and also internationally. What the Commission is proposing is to establish a global court for transnational corporations and other foreign investors. a court that would only take into account the very far-reaching rights that they get in today's investment and trade agreements. And we know how they use these rights through the ISDS system. They use these rights to pressure decision makers, to attack decisions that are in the public interest, protect public health, consumers, workers, and the environment. And they use the system to get public money that they would otherwise not get. What the Commission proposal does is, rather than abolish this system, lock it in. This global court for corporations means ISDS forever and for the world. And I don't want to lock in a legal system that has proven to be against the public interest. I don't want to institutionalize, to cement a system that can force governments to pay when they do the right thing for their people and our planet. This is why I think this proposal should be put in the bin.
Yes, first of all, I have to apologize, but the mandate of the Commission came too recent to get my association the opportunity to have a proper position. So what I'm talking about today is not the position of the German Judges Associations, but just my own one. I'm a member of the board. So we will see what official position we are going to take. I would not take the MIC forward. Why? To come back to when it all started in the 1960s, the then Council of the World Bank, Aaron Brocious, finding problems for a worldwide consensus on investors' rights, proposed the creation of an institution to settle investor-state disputes, which would establish its own substantive law. He called this under the formal procedure before substance. And this is the situation we are in today. We still haven't found substantive law in protecting investors' rights. And if we would create a court, we would create a court without substantive material rights. And I think that is wrong.
Thank you, Nele. I guess you're the only defender here.
Well, absolutely. Picking up where Paul left it, I mean, he did recognize that a lot has changed in the ISDS field, and precisely in the EU we have reforms, we have enhanced the limitations of the existing ISDS, and we have worked on the efficiency of it. There is an investment court system in place in our newer agreements. So building on that one, obviously there is a sense that there is an efficiency gain to be had from moving towards a multilateral court. If we think about it, there are about 3,200 such investment agreements out there. They exist, it's a fact. So we have a choice whether we do something about it, whether we try to reform the system globally, or whether we don't. The Commission has clearly put out a proposal to contribute to the global rules-based approach, to the reform of the system, and therefore the proposal was put out there. Now it is obviously for the Council to decide whether they authorize the Commission to start negotiating. But clearly the Commission feels that there is an important void to be filled to move towards a more permanent, independent, and legitimate multilateral system.
Thank you. Now I heard a lot about procedure rather than substance. Goose, you've been very critical of ISDS over the years, and now we have this court, this proposal. And you said, actually you were the milder of all, you said it's a little bit vague, but I support it in principle. What do you mean by it? What is the principle? I mean, it's the idea, or is it the proposal itself?
Well, I think there is a role for international adjudication to resolve some kinds of very sensitive disputes that can't be resolved in domestic courts. When you use international adjudication for that purpose, it has to satisfy basic standards of judicial independence, procedural fairness, and ISDS does not. So from a position of principle, ISDS shouldn't be used in that way, and there needs to be another approach. So I'm a hopeful person at heart. So when there's a proposal for an international adjudicative forum that could satisfy those criteria, my inclination is to trust. But I also have to keep in mind that there is evidence thus far that calls into question the credibility of the proposal, and ultimately the proposal can't be judged until there's a legal text that can be analyzed. For example, when I speak about respect for domestic institutions, ISDS and the investment court system in the Canada-EU CETA, they effectively assume that domestic courts in all countries are so systematically inadequate that foreign investors should be able to bring international claims against a country without providing any evidence or argument at all that there is something wrong with the domestic courts in the particular country where they have an issue. That is dealt with very differently in other areas of international adjudication because there is a duty of the claimant to exhaust local or domestic remedies where they are reasonably available. And that duty has been removed in both ISDS and ICS, and I have seen no evidence that there is a commitment to reincorporate that duty with respect to the proposal for an MIC. And without that duty, in effect, you deny to a country the ability to resolve an issue within its own domestic court system if the foreign investor chooses to sidestep the courts. You deny the international adjudicative body a record that emerges from the domestic court system. And you create various other opportunities for creativity and, frankly, mischief by the lawyers that have been representing the claimants here. It's foreign investors. So that's just one example of how I would like to see clearer commitments and red lines and preconditions to ensure that the MIC is respectful of domestic institutions, but also independent and fair and balanced in a way that ISDS and ICS are not. Before I can go beyond support for this hopeful idea in principle.
Peter, you have been called into question here with the domestic court. Do you really think the proposal and the idea itself is biased towards domestic courts? Your own, I'm not asking the organization you represent, but you as a professional in this field and as a judge.
It's hard to tell. International investment law is something different from national law. And if you look at most of the cases being settled and being published, these are cases which sometimes have been taken to national courts. Sometimes parties have won, lost some cases, and then they're going into international arbitration, which is a completely different area of legal systems. And therefore, I think the main problem still is within international investment law that we don't have proper law. We don't know actually what it's all about. We have some standards, the fair and equal treatment standard as the general approach, other standards, but we don't know how we going to have an interpretation of this, and we don't know how we are going to have an interpretation by an MIC if it's going to be established. And I think this is the main problem. A court needs law to apply, and we still don't have the law which the courts could apply. And this is all about, and this is, I think, the main problem of the whole discussion, that there is still no law to apply. And if you look at the mandate, it comes clear there. It says, and I cite, matters such as applicable law and standards of interpretation, consistency with other international obligations will be addressed in the underlying investment agreements. This means we just don't have substantive law at the moment when we create the court. And then, in the attachment dealing with the obligations of the MIC, it said that the appeal tribunal shall review the decisions of the first instance on errors of law. But how can this tribunal can do it if there is no law? It can only then create its own law, and then we are going to establish a court which has the right to create its own law. And I think this is the main problem.
So it is a little bit what Pia was saying. It is basically a rehash of ISDS, or is not?
Well, it's better and worse. Better is, of course, we are going to have standards on procedure. We are going to have standards of publicity, and maybe we're going to have judges which are in a way independent. But on the other hand, these judges then are, as it is a court, are creating law. And if you have ISDS, well, you can't stop parties from going to have an arbitration. But the arbiter, well, can do what he likes in a way. He is not creating law.
Pia?
But a court is creating law.
Well, maybe just to explain why I insist on calling this global ISDS, multilateralized ISDS, and I think it's just not right to say that ISDS is gone with this proposal. ISDS means investor-state dispute settlement. It doesn't necessarily say this is happening in an arbitration system. This is how it's happening today. But investor-state dispute settlement is what is going to happen in this multilateral court. It is a court, but I am very wary of this whole court rhetoric, because I think just the name court, when you use it in a public debate, people trust in courts. They think of our national courts, but these courts apply a very different law. They pay a law that is there for everyone, that also balances different societal interests and has been developing in a long time. And this will be very different with this proposal. As I said, it's a court that is only accessible to some of the most powerful actors in society, foreign investors. This is not the plumber from around next door. This is not the person on unemployment benefits. It's only accessible to capital owners. And the law that will be applied, whether there is a law or you just take the law that is in the treaties that we have today, is again a very biased law. It only knows rights for this group in society. So this is why I insist on this is a global court for corporations, that it will apply corporate law. This is nothing but ISDS for the world and forever.
Nele, there are quite a few questions here. Maybe you can start with the first one. You know, international court versus domestic court. Is it creating anyway an institution for powerful, as we heard, powerful foreign investors? And does it create, is it standards on, does it create its own law de facto that is beyond the regular law?
I mean, the way the initiative has been put out there, has been conceived, is basically to empower the body to hear disputes over investments between investors and states that will have accepted this jurisdiction. So this body will deal with procedural issues. It is intended precisely to to be a body which adheres to specific standards, specific rules, but the beauty of it, if we wish, is its permanency, it is the appeal mechanism, it is independence of judges, and it is transparency. But in that sense, there were lots of questions about, you know, the interaction with domestic law, domestic courts, exhaustion of local remedies, and so on and so forth. But what the Commission has proposed is actually an initiative, and I have to sort of reiterate it. It will deal with the treaties that have been entrusted for it to be dealt with. So therefore, the law that, or the treaty provisions that are there will be handled as such by the court. So the court will sort of not make the treaties more uniform. So therefore, if let's assume there is a bilateral investment treaty between two jurisdictions, two countries, the rules that are foreseen therein will then be applied by the court. On the issue of whether it is only the large investors who can have access to these courts, as be asked, I mean, again, this is a question which will depend on very much whether access to ISDS is foreseen to others than investors by the agreement as such. So, I mean, the proposal, if you look at it, I mean, it envisages that it would be open to also for small and medium-sized enterprises, but also to natural persons. We are trying to see in parallel whether also something could not be done to address the disparity between developing and developed countries. So therefore, it is intended to be a proposal to improve global governance.
Now, before I ask the next question, I would like to remind our, so this discussion is live streamed. We have people listening in. So we have a hashtag called MIC Alternatives, MIC Alternatives, however we want to call it. So we'll take questions from viewers and also from the audience here. So be prepared to ask questions at the next round. Now, I would like to ask you all, because from definitely not an expert that I am on the topic, I hear lack of ambition. It seems that the Commission had to do something, and it came up with this proposal, which is very procedural, as you mentioned. It has an appeal mechanism, it has the independence of judges, it has the transparency. But is it the minimum common denominator that you had to try to do just to put some order in the ISDS and move forward, for example, on CETA and Vietnam? And isn't it better to be much more ambitious and create something that would be really restructuring completely the system as it is today? Also, there is another question, is what do we do with all the treaties that have been, there are thousands that have been already, that are already in place. I'm asking all of you this, are we talking here about the fact that the Commission has not been ambitious enough? We want more? What do we want, really? I'll start with Pia.
Well, I would say we want something completely different. We want to go in a different direction. That direction would be, for example, that countries, EU member states, start terminating their investment treaties. One good thing about bad treaties is that you can actually get out of them when you've made the experience that they didn't bring the promised benefits and were actually harmful. So treaty termination is one alternative, and it is pursued by many countries around the world and a growing number of countries around the world, and some representatives of these countries we will hear later on the panel. But we also want to see a change of course in another direction, and that was what Paul mentioned in his introductory remarks. We don't think that in today's globalization system the problem is not enough rights for foreign investors and companies. We think the biggest problem is that the more vulnerable actors in societies, be they workers, be they local communities, and also our environment and the planet, they deserve stronger protection in international law and stronger enforcement mechanisms for the international law that is there to protect these interests. So this is very different. It goes into a completely different direction than what the Commission is proposing, which is meaning institutionalizing, expanding, locking in corporate rights without strengthening any of the rights of the other societal interests. So it's not about a lack of ambition, it's the completely wrong direction I think we're heading to.
Peter?
Yeah, well, if there is a need for a special investor protection right, then I think we should start talking about the substance of this right. It is all coming back to substance. I don't know if there is a need for it or not. This is not for me to decide. But if there is a need, we do need proper material legal regulations about it. We need a proper legal definition for fair and equal treatment standard. And if we do have this, then a court might be a good idea. But before we don't have this, we can't institute something like a court.
So, Gus, are we going about the wrong way? Are we missing something? Is it just a baby step, really?
I think you have to think about where are we now? Where are we? And where are we, where does that step start from? And from my perspective, many countries are not in a very good place. Most treaties that allow for ISDS were concluded before there were any foreign investor claims. Research by my colleague in London, Lauge Paulsen, excellent empirical research, indicates that governments did not carefully consider their decisions to enter into these treaties. If anything, they were entered into almost just based on a pure belief in the promised benefits without any consideration of the clear and serious risks and liabilities. So countries then were shocked when they found that these investment protection treaties that they signed with the Cultural Cooperation Treaty could lead to a risk of billion-dollar liability. What? And now they're caught in a legal trap. The treaties were designed to be very difficult to get out of. Someone designed them that way. There were a few who were aware of how this system was supposed to lock countries in. Another colleague of mine, Federico Ortinho, he summarized this system, if he had to summarize this system in one word, gotcha. Gotcha for the state, for the sovereign, who's locked in and is stuck. The treaties they have minimum terms, they carry over. ISDS in trade agreements is particularly pernicious because to get out of it, you have to leave the whole trade agreement. At least bilateral investment treaties can be terminated and should be terminated if they can't be renegotiated to make something that is acceptable, and we're a long way from that. So if you think about being in that place, being in a trap, you look at ways to get out, and different countries will have different options available to them. So for some countries, the option of renegotiating or withdrawing from bilateral investment treaties, withdrawing from the ICSID Convention, those are potential options that can be pursued, and they would be effective in correcting this historical gaffe or error of an older era, especially the 1980s and 1990s, when no one really expected these treaties to evolve in this way. But for other countries, that option is not available. And if the MIC would provide a viable alternative for them, and the MIC met, at least in my view, the necessary criteria of a balance in the allocation of rights and responsibilities, judicial independence, procedural fairness, and respect for domestic institutions, then that could be a very positive possibility. But with that in mind, it's called a multilateral investment court, but in my view, it's more important to get the right kind of institution than to make it multilateral. I would prefer, if there were only 2 countries in the world that would agree to a proper institution, I would much prefer that to another flawed institution that many countries have signed on to. So have high aspirations in terms of the quality and not in terms of the quantity of countries that are going to be joining it. I thought 10 or 20 countries would be a nice start to design something that was far superior to what many countries are stuck with at the moment.
Nele, lack of ambitions, but also, I mean, you heard from Goose, why not start also renegotiating some agreements if some of the countries that you mentioned are also within in Europe?
Well, it would appear that in the UN context, I mean, UNCITRAL has taken the decision to discuss multilateral ISDS reform. This decision was taken in July. Work is now starting off in earnest. It is indeed very, very important to discuss the issue in a broader sense, as you rightly said. It is clear that there is, beyond Europe, there is a recognition that there is an issue, that the current setup is not perfect, right? So, so this reform discussion is now taking off. It is very important that this discussion takes place in the UN context, which means it is transparent, which means members and observers can take part, NGOs can ask to be accredited, so that the views can also be made known in that context. So I think these 2 strands are very much complementary. The work that the EU has done and now proposes to do in a more global context, and obviously the actual reform discussion on the ISDS ongoing in UNCITRAL.
But where there is problem, is it, and to get out of the gotcha situation, is there a way that we can show, I mean, when there is a problem, as you said, you get the bull by the horns, right? So would that help the process of the MIC, of the MIC, if we actually starting treating those treaties that are badly designed? Do it in parallel, so that actually you start dealing with the 2 problems. You deal with the problem, and at the same time you create something different where there is a good, a positive momentum that brings other people on board, other countries on board.
If I may say, the Commission is signing new gotcha treaties at the moment. So I mean, just so that there is no wrong impression that the Commission, in parallel to establishing a court, is getting out of treaties or asking EU members to get out of treaties. No, we have signed the EU-Canada agreement. The EU wants to negotiate investment protection rights into the agreement with Japan. At the moment, I think no EU country has signed a bilateral investment treaty with Japan. This is about a crazy expansion of the problematic system, not about getting out. So just so that is clear. And I think we really have to see the Multilateral Investment Court as part of this wider agenda. And the EU agenda is not just about locking in the system, but it is really about expanding it, which will mean concretely higher risks of being sued for EU countries and the trading partners, higher risks for public budgets, more pressure for legislators who want to do the right thing. So this is what the Commission agenda is about. It's not about actually addressing problems. We are at the moment making these problems worse with treaties like CETA.
If I may counter that one, I mean, you all were involved in the reform process of the ICS that led to the investment court system. This investment court system was a result of a lot of deliberation, precisely to balance the interest, take into account the concerns that were with rights of regulate and so on. And this is the system that is now being agreed in CETA and in Vietnam agreements. So therefore, this criticism is a bit unexpected because all of you were involved very, very much in this process. So we feel that at least the views should have been represented quite adequately. But another issue on what you termed or coined as gotcha treaties, one aspect of them could actually be that it would allow for claims to be grouped. So precisely as to prevent that investors are able to bring, all over the world different long-shot claims. So the beauty of one body could actually be that this would not prevent, but definitely dissuade investors from giving it another try. So therefore, there could be a sort of an upside to grouping the claims and having one single entity to look at these various disputes.
I don't want to get too much into CETA, but obviously there needs to be clarity here a little bit on you come from Canada. I can't refrain that question, but you come from Canada. What is, I mean, are you happy with what's in CETA? Is it really? No, because I'm questioning, since we, is it really a got you still agreement?
I think ICS in the CETA is not good enough. And I can explain why. The positive aspect of ICS is it did take significant steps to address aspects of the lack of judicial independence in ISDS by providing for a state-appointed roster, by prohibiting side work by the arbitrators as counsel, and by incorporating an appellate body. Those are all certainly positive steps. But on the point of judicial independence, there are still limitations. One, the ICS roster members would still have a financial interest in the frequency of claims by foreign investors. And they're not prohibited from working on the side as ISDS arbitrators. And we know that there are entirely secret ISDS cases under some treaties, meaning that disputing parties and anyone else will have no ability to reliably verify whether an ICS roster member is working on the side and being paid on the side by a particular interested party in ISDS. So that's on judicial independence, and that's the happy story. On procedural fairness, ISDS is so fundamentally unfair in my view, because the only affected parties that can be represented are the foreign investor and the national government. But these disputes can have very great significance for other parties. For example, Chevron is embroiled in litigation with Ecuador and has used ISDS to challenge the court decisions that have emerged from Ecuador in response to claims brought by plaintiffs, victims of contamination of the rainforest in Ecuador, who attempted to sue Chevron in the United States, and the US courts at Chevron's submission redirected the plaintiffs back to the Ecuadorian courts. And when they went to the Ecuadorian courts, Chevron sued Ecuador under ISDS to challenge the use of Ecuadorian courts. And in the ISDS litigation, where the ISDS tribunal actually ordered Ecuador to stay the enforcement of its court's decisions, which is a bit of a challenge for a government intervening in an independent court system, the plaintiffs in Ecuador could not even be represented as parties with full standing in that ISDS proceeding. They had a clear interest in the outcomes of the ISDS proceeding, and they had no right of participation as a party with standing. That is a principle of fairness that goes back to Roman law, that all affected parties have a right of full participation to the extent of their interest. It is missing in ISDS. It is a glaring gap from the simple perspective of a fair process. It was partially addressed in an article in the original version of the ICS as proposed for the TTIP, but that article was dropped from the CETA. So as far as I can tell, someone made a conscious decision to keep it unfair in the ICS, in the CETA. And I'm not happy about that. As an academic, as a Canadian, whatever you'd like to, however you'd like to frame my perspective. So procedural fairness, that's what I mean. There is a credibility gap here, and I would like to see clear commitments to what the European Commission really wants. It's not so much a matter of what other countries want at this stage. It's what does the Commission want? What does my own government in Canada want? And what will they clearly commit to as red lines? The other aspects, balance. Foreign investors should not have the most powerful rights and protections that exist for any private party in international law, by far, without responsibilities that are enforceable in the same process. There should not be rights, extraordinarily powerful rights, without responsibilities. It's a very conservative position, I think. And that is the essence of ISDS. And it is still the essence of ICS. And the last point I had mentioned earlier about the respect for domestic institutions is an ongoing difficulty in ICS, that the obvious step to me, I don't even see why you need ISDS or ICS in agreement between Europeans and Canadians. We like each other so much. What's the matter? We don't trust each other now all of a sudden? And we need this incredible mechanism that has very rarely, in fact, really the only clear example of it being applied between developed countries is Canada and the United States in NAFTA before all the claims came. So they kind of have an excuse for that gotcha mistake. But we don't have that excuse this time. It doesn't belong in this agreement. So I hope I didn't go on too long for you, Danielle.
No. I'm actually, you pointed to one element which I think we should try to discuss, because when it comes to procedure, you said all affected parties have the right to participation. So and it seems that this has not been, internalized in the thinking up to now in creating new structure. Is that the reading I have, or is it, is it only, it's true that ISDS was only for foreign investor and state, as Pia pointed out. But with a court, do we have the ability to include all parties here? Or are we still sticking, and why are we sticking to the still investors and state? Am I asking the right question?
I don't know if you want to.
No,
But very quickly, what the answer from proponents of ISDS, some treaties allow for amicus representation. And there's a lot published about amicus. Amicus is a pathetic substitute for a right of standing when you are an interested party. It's at the discretion of the tribunal. It's a very limited form of participation. There's at least one case I'm aware of where the tribunal acknowledged that another party had an interest and was still denied amicus. Many treaties do not provide for amicus. It's still relatively rare in the process. So there's a lot of attention on the distraction and an avoidance of the core lack of fairness. It's not, ultimately, the more important point is interested parties must have a right of standing. It's nice to have submissions from informed groups who can help a tribunal. That's what amicus is for. But the right of standing is missing here, and it's a really serious problem of procedural fairness.
Would that, please you better if that, interested parties have the right of standing be there?
When we can talk about many small, good, positive aspects that we could integrate in this proposal, and some are in there. But the point I'm making is, even if you include these improvements, we are paying a very high price. The price of, as I said, locking in a dangerous system, going along with an expansion that the EU is also pursuing. So this is a bit like swallowing a poison pill just because someone says it also has vitamins in there. I wouldn't do that. Just don't swallow the poison pill. We can talk about the vitamins, but I think it's the wrong debate.
Yes, I want to come back to what was just said, and I think it's a daily work of a national judge to protect property. This is what we do, and this is what quite a lot of work is done on in national courts. Looking at Canada and the member states of the European Union, both have well-functioning independent judicial systems. So there is no need for anybody for a special system of protecting property for a special kind of party. And if there might be some flaws in national legal systems for protecting foreign investors, if there's a lack of substantive law in protecting them, then you could put into a treaty changing the material law within this country. So you don't need to have a specialized judicial system for protection of foreign investors. You can change the material law. And this is what I am very, very disappointed about. CETA treaty, for example, it's between Canada and European Union. Both countries, or legal systems, the European Union with functioning judicial systems. It might be different if you have a treaty with a country in which you have the feeling that the judiciary is corrupt and is not working, and the whole administration is not functioning well. But to start such a system within countries which we are very close, and we think both have functioning judicial systems, I don't know why we're doing this.
So it would have been to scrap ISDS and have nothing in with CETA completely. Okay. Now I want to open the debate to the floor. I think, can you please, there are little microphones in in the side of your seat. So I see one question over there. How many questions? I'll take 2 or 3 at the same time. So please raise your, unless there is 2. 2 for 3. Okay, 4. I'll take 3 for now. The gentleman in the back.
Yes.
So can you introduce yourself and then
yes,
ask who
Michel
the question
van
is directed to?
Coordinator of the Left Ecological Forum. That's a movement beyond parties in Belgium. I think the most fundamental issue was raised by Mr. Eberhard. is how can you have a court without laws? Courts are made to apply the law. And the laws are made in democratic countries, are made by democratically elected parliaments, and that have the power to make laws. You have this system in countries, separate countries, in a number of them in the world, not everywhere. But and in Europe we have a parliament, but which is powerless. It cannot make laws. So the only system democratically made laws are in national countries up till now. I rather prefer you have a democratic Europe with a democratic parliament that can make laws. I rather even have, it's a utopia, a world government and a world parliament democratically elected that can make international law. As long as we don't have that, we should only apply the national laws. And national laws are there to protect the people and not the multinationals. I think we must protect the people against the multinationals.
Thank you. You made your point. Yeah, over there.
Hi, my name is Michel Chermak. I coordinated the Stop CETA campaign in Belgium. My question would be to Mrs. Eichhorn from the Commission. If I'm not mistaken, you said that the Multilateral Investment Court could maybe protect the rights of other actors than transnationals if those rights are enshrined in the treaties. That's maybe not the best place to put that, but I'm just curious in the attention of the Commission to maybe introduce human rights protection in investment treaties. Is that in the plan, or are you just mentioning that, but actually not planning to act on it? And then a more general question, because you will not be in the second panel, and I would be really interested to hear you about this. Is the Commission not seeing the super growing distrust with the corporate-driven globalization? And do you really think that creating a new court dedicated to transnational to sue states is the answer, or is there not a priority to first better protect human rights against violation in the global value chains of transnational corporations? Thank you.
Thank you. Here? You have the micro in your seat. Okay, maybe I'll take the fourth question first, and we take 4 questions. Please, go ahead. Sure.
My name is Bernd. Can you hear me? Yeah. My name is Bernd Schneider. I work for a member of the European Parliament, which does make legislation, actually, by the way. We are co-legislators in the European Union. I work for MEP Helmut Scholz, who is coordinator of GUE-NGL in the Trade Committee. I have 2 questions. First is, how does MIC, in your perception, relate to the Energy Charter? The Energy Charter is now the #1 agreement that is used to start claims against governments. It's in this concern, it's more dangerous than a lot of the bits that are existing. And will there be like an agreement-picking possibility for corporations then to still use the Energy Charter to start their claims, or is the Commission actually considering to move out of this lock in the Energy Charter and to do something there? And the second question is, in the view of many, it's not so much expropriation that is happening that is a problem. That's something that happens in all the countries. It's normal. It's in the legislative forms. Also in Sweden, you can expropriate companies, and then there's a court deciding on how much you get for that. In Germany, we don't know, for instance, and that you can claim expected profits. That's something we don't have in the German law. Right, but that's what you get with ISDS. But I think the problem is more that people suffer from violations committed by corporations. So there was more hope to have an international court where you can claim against environmental crimes, against bribery, maybe against other forms of crimes that have been committed. Have you ever thought about including like obligations of investors into this approach? Thank you.
Okay, I think we have, I'll take the 4th one so that we have a big round of questions first. And we'll
Okay, my name is Etienne Lebeau. I work in the Belgian trade union CNA. my question is, further discussions on the MIC will take place at UN level at UNCITRAL. And my question is it a good idea to do this discussion in this body, as it was at the center of the arbitration industry? So if we want a fundamental change in with the MIC, shouldn't be a better idea to do it in another body than UNCITRAL?
Okay, so who do we want to, maybe a court without laws? Go ahead.
So on the first question, I mean, we have an example of the International Criminal Court that also works without one single substantive set of law. So therefore, I mean, we are not saying with this proposal of the MIC that the Commission is against future multilateral negotiations on a substantive law, but the MIC proposal, as it is put out there, deals with procedural law. So we have to sort of work a bit in parallel here. On the question of whether UNCITRAL is the best placed body to discuss these things, therefore it's important, as I said, that there was in July a decision sort of taken on the working groups and on the procedural aspects of how this reform will be discussed now multilaterally. It is obviously up to the members to decide who they nominate as negotiators to this process. So, because the Multilateral Investment Court has a different logic than pure commercial arbitration. So we have reason to believe that it could be also different people to discuss this particular reform, but it is really up to the members who they will obviously nominate to discuss. And there was a question about the Energy Charter Treaty. Yes, we have, the EU has been pushing for reforming also the substance of that. It has been very difficult. On the issue of whether Multilateral Investment Court could also deal or apply the Energy Charter, we will have to see. This is now a start, but we will come to that question, I'm sure. Thank you.
Well, there was a question on human rights protection in investment treaties. I think it's a crucial question. Do you have anything to say?
I mean, what we are doing in trade agreements currently, and there is also a process of consultation ongoing, is to look at the sustainable development angle and the chapters of sustainable development in trade agreements. So this is very much also about improving the labor and the environmental standard part. So there we are very active. On the human rights side, I will have to get back to you.
Okay. Who wants to react on different questions? Goose, maybe?
Sure.
Maybe on corporate-driven globalization, etc.
Energy Charter Treaty. I don't see too many options beyond withdrawal. It's going to be very difficult to fix that one, and to think you're going to do it somehow through the MIC process. The Energy Charter Treaty is another NAFTA and the Energy Charter Treaty are the two examples of these gotcha treaties from the early 1990s that trapped developed countries in their relationships with each other. And they've generated together probably 25%, something like that, of all known ISDS cases. So those are the two big kind of creatures in the room. I did want to make a comment on the UNCITRAL forum. I haven't looked at this closely. I'm sure the European Commission has a thought process for this, but I didn't see that as too encouraging, having it done in UNCITRAL. And the reason is, when UNCITRAL reviewed the UNCITRAL arbitration rules, which are available under investment treaties for foreign investors to bring claims against states, commonly used rules along with the ICSID rules, UNCITRAL reviewed them to bring a transparency into treaty-based ISDS. And from what I understand from persons who had access to the discussions and the negotiations, the ISDS legal industry was well represented in that process and apparently succeeded in having the new transparency rules only apply to future treaties. Normally, you would expect those new arbitration rules to apply to all future claims under all treaties. So there was a successful maneuver to gut the impact of that very important reform, because it means all kinds of arbitrations in ISDS under the arbitration rules that are filed under treaties that predated the revised rules that include the transparency obligations, those can all still be done in secret to varying degrees. That is, to me, a troubling precedent. Likewise, I understand that there are a couple of candidates now for the Secretary General of UNCITRAL, and one of them has a history in UNCTAD at a time when UNCTAD was organizing sessions with governments where the ISDS legal industry was well represented to discuss ISDS. So that also is not too promising for me if UNCITRAL wants to be a credible forum in which to allow a clean break from ISDS, which is definitely needed.
You don't want to react on other question? I mean, the human rights?
Can I say on the human rights?
Yeah.
I mean, obviously, it is clear that the Commission proposed mandate or proposed negotiating directives foresee as well that obviously we are not opposed to other treaties becoming under the Multilateral Investment Court, but this is just the start of the process, so other partners will obviously need to have their say about this. And on the UNCITRAL reform, again, I have to emphasize that this is a very transparent process. So actually, the mandate is out there, and there is a strong emphasis for this reform process being a government-led one, as opposed to investor-led one. So this is just to come in.
Yeah, but the transparency on all treaties or just new treaties?
No, I'm talking right now about transparency of the process of reforming the ISDS that is ongoing.
But this is definitely a question. Does it apply to all treaties, or does it only applies, I mean, we heard the thousands of treaties, or does it apply just to new treaties? So that needs to be, it's a big question. Okay, maybe you don't want to react on any of them?
I guess I already talked about human rights. I have the feeling that the questions have been addressed. Maybe just to add on the Energy Charter Treaty, that was a question that I also had for the European Commission, because the draft mandate is pretty explicit in a footnote saying this proposal does not apply to disputes that will come under the Energy Charter Treaty. So apparently the Commission is aware that the claims that have hit EU member states hardest and most often in recent years, and will continue to do so, will not have anything to do with this proposal of establishing a global court for corporations.
Okay, Peter?
Yes, perhaps I will pick up the question about obligations of investors. And I think it would be quite helpful if we could get a proper system of working international legal assistant in these matters. And if we could perhaps integrate a system into all these trade treaties, which would guarantee, for example, cross-border criminal investigations into corporations more easily. I'm working as a prosecutor, and it is quite difficult sometimes to investigate cross-border when there are alleged tax frauds or other things within corporations. And I think it would be rather helpful for us if we could integrate into these trade agreements that investigations cross-border into corporations of other countries would be more easy.
Okay, so I don't see any, unless I'm told otherwise, I don't see any questions from Twitter. So we'll continue. I see one question here, 2, 3, 4, 5. Oi. Okay, we'll do 3 and then maybe we'll do the 5. And then we'll answer. Please.
Yes, I would like to microphone. I would like to go a little bit further on the human rights issue.
Maybe if you stand up and talk to the room.
In February at the multi-stakeholder meeting with Commissioner Malmström, this issue was brought up as well. And the Commission said, looking into human rights issues, interesting, but we'll have to look into it. Then 4 months later, we presented to one of your colleagues in the cabinet, we presented 300,000 petitions against the MIC. And we talked about the human rights issue. What is the Commission going to do on that? And the answer was, interesting, we come back to that later. We bring the issue here again, and you say you'll come back to that later. I would like to urge you to be a bit more precise on that and maybe outline what kind of process you have in place to look into that, so you don't have to come back to it later again when we ask about it. Also because the UNCITRAL mandate is larger than just the MIC proposal. So it might just be that other countries from the Global South, for instance, would say, well, we want to talk about human rights issues related to investment as well. And I would like to know, what is the Commission's response going to be? Are you going to argue, no, this is just about investor rights, or are you open to also discuss about other rights? So that's a question. The other question relates to the consultations that have been taking place on this issue. I was quite taken by surprise when I read in the draft mandate from the Commission that the Commission argued that there is generally broad support for the proposal for a MIC. Now, the Commission has organized 2 public consultations on this issue. The first one 2 years ago, there was a 97% of the respondents who said very clearly, we don't want ISDS in the first place. We don't want a reform, we don't want a system. Now again, there's a second consultation that took place on the MIC. We looked at the consultations. We're still in the process of looking at the responses because it's quite a big picture with a lot of questions. But so far what we see from the respondents is not at all a broad public support. There is a small support from very precise groups, but the overall picture is actually that most people actually again said we don't want this system. So I would like to hear from you where the broad public support that the Commission claims is based on. Thank you.
Thank you. No, I saw. Can you raise your hands again? Over there. Yeah, please. The lady.
Good morning. I'm Brennan from the Transnational Institute. And I would like to come back to the point that's been made about the millions people who carry the cost actually of the operations of investors and transnational corporations throughout the world. And I think it's quite important to also bring to the panel the fact that as far back as, well, I think over the decades, there's been a concerted effort by governments to actually have a different system, to have a fundamentally different system, the most recent of which was put on the table of the UN in 2013 by 80 governments saying that we want to create a legally binding instrument for the operations of transnational corporations and other business enterprises. This was finally mandated with an intergovernmental working group to go forward with a proposal on that and with a proposal for a treaty, which will actually come on the agenda of the UN this coming October. What I would like to sort of, to put to the panel and also to the Commission representative, the timing of shifting the whole debate about ISDS to UNCITRAL, and now the fact that there is a process actually in the UN where the Commission has been systematically undermining and has stated with its own representative last October on the floor, we're very reluctantly in the room to follow this debate and this discussion. It is a historic opportunity to move in the direction of a fundamental change, and would like to know really, has this at all been taken on board by the Commission representatives who are working on the MIC, and are these departments working very separately from each other? And this is really a historic opportunity for a constructive way forward.
I saw next to over there. Yeah, sometimes they don't work. Try to use your voice.
Okay.
Carry out.
So I'm Juliette Renaud. I'm from Friend of the Earth France. My question is also to Mrs. Ashram on the human rights side. So as my colleague said, the EU is quite reluctant to participate to the negotiation on the UN treaty in Geneva. But what I want to ask is that the EU and the other northern countries that oppose this process say that it's because we need to give a chance to the UNGP, so the United Nations guiding principles that are voluntary norms to protect human rights. So what I want to ask is why do you think that we need so much effort to build binding rules to protect investors, and that we don't need any binding rules to protect the environment and the victims? And we are speaking of people that are waiting for justice for many years, or more than 200 people, environmental defenders that have been killed last year. So we are really speaking of an urgency.
Clear. It's the same question coming over and over. There was another question right here, please.
Hello. Okay.
Yeah, it was.
I'm Diana Powers, a journalist. I have a question about sort of the basic constitutionality of the whole way the whole ISDS came about, and now the MIC. And are there no constitutional protections of any country that prohibit another arbitrary private court from superseding decisions that are made legally through the law system, legislative system, and the judicial system in a country, from being superseded by some other court? And is it possible, the next question, which is part of this, is it possible for countries to put in such protections for its own legally arrived at conclusions that would then block ISDS decisions from dominating over national decisions?
Okay, you're obviously a very expert journalist in judiciary systems. I'm going to give you the floor last this time, and I'm going to turn to my left. Any reaction, Pia?
Yeah, maybe I would like to pick up Paul's point, because, I mean, Nele, you also said, oh, I'm so surprised that you're so critical. You were also involved in the reform process. I've been involved in a 4-year or 5-year-long very intense debate over ISDS in Europe. And it was and continues to be a great debate, the debate that this issue deserves. In this 4 years, we have millions of citizens who didn't say we want to have a roster of arbitrators. They said we don't want a parallel justice system for corporations. We have municipalities who have raised concerns. We have a growing number of academics, of lawyers, even as SMEs, and their concerns are not, you know, some procedural little tweaks. They have big questions on this system. What is the public benefit? And until today, the Commission and other ISDS proponents are not able to answer this question. What is the reason for taking one group of social actors out of our judicial system and giving them rights that no one else has, and rights that they have used to attack all kinds of things that we are fighting for, and to walk away with money that they wouldn't get in national courts? So this was what the opposition is about. So therefore, I really want to reject the impression that this opposition is somehow represented in the Commission proposal that locks in the system and expands it further. The Commission proposal is ignoring these voices that have come really in thousands from citizens and from organized civil society. And I'm pretty sure that some of the groups here represented in the room also wouldn't say, well, our points of criticism are very reflected and balanced in this proposal.
Peter, maybe on the lady's question here.
On the question of yes, overruling national constitutional courts and courts. Well, I'm very happy that the Belgian government at least is taking Kita to Luxembourg, and we will see what is coming out of that. And I still don't know what the German Constitutional Court would make out of a mandate if the German government and the Bundestag would give a mandate to the Commission to negotiate MIG, if this would be regarded by the German Constitutional Court as well, what we call a Solange decision, which would mean that the power is going up to Europe, and is being accepted by the Constitutional Court that it's going to the European Commission as long as fundamental breaches of German constitution are not at stake. And this might be the case. I still don't have checked this, so I can't give you an answer. But yes, it is a constitutional problem for national member states as well. And because, of course, power is going away and a completely new court system might be introduced, again, without substantive law. And it's not just, the MIG is not just about procedure, it's about giving an award. And this award means the procedure towards the decision and the substantive law behind the award. So, and with this appellate tribunal of the MIG, we are creating a very, very powerful judicial institution indeed, which can overrule, or at least it has to overrule national decisions. Otherwise, there would be no sense in having such a court. And it might even overrule constitutional courts. And this, of course, raises issues of national constitutional matter as European law as well, yes.
Okay. Gus?
Following on those very insightful comments from Peter on the last question, one reason why this system is so extraordinarily powerful for foreign investors is the awards in their favor from ISDS or ICS tribunals can be enforced against the country's assets in many other countries, and relatively easily. And you don't have that international enforceability of domestic court judgments or other international courts, meaning in any country you could have a decision of the national parliament that has been reviewed in the country's supreme or national court, found to be lawful, to be upheld. Most citizens think that's where it ends. That's sovereignty, that's democracy. Or in the European system, it ends when it's a matter of EC law at the European Court of Justice. But with ISDS and ICS, it doesn't end there. It's not final because any foreign investor can trigger this authority of a final tribunal, which is ISDS or ICS, and those tribunals can order a payment of very large amounts of compensation, which in effect means countries or EC institutions lose control over the budgeting of their decisions. How much will their legislation cost? How much will their court decisions cost? They don't control that anymore. It's ultimately a special avenue of access to public money that is available only to foreign owners of assets. I'd also like to thank everyone for attending and being so hospitable as usual. It's always a great pleasure to visit people in Europe and discuss these issues.
We're not done.
Oh, I thought we were.
Nele.
Finally, so I would simply like to again, as on the Energy Charter Treaty, just to set the record straight. There is a footnote in the draft mandate which talks about intra-EU cases. And when I said that the MIC could also be applicable later or could apply also the Energy Charter Treaty, then I talked about the extra-EU cases. So to be clear, on the human rights, obviously this is an immensely important issue. It is I'm very sorry that you have that perception, but as somebody rightly recognized here, the EU is now fully engaged in the UN process on the possible binding law on corporations. So this process is also ongoing, as is the MIC. MIC will probably take years. So we will have to see whether the human rights law in the future can also then be subject to the MIC or not. But at this stage, it is simply premature to predict. But there is commitment, so no hesitation on that front. Thank you.
Okay, we're getting to a close. I'm conscious of time. We are 10 minutes over time. But I would like, in one word again, not even 1 minute, in one word, because it's very easy to criticize the Commission. I mean, I feel sorry for always beating on the Commission, but if you were in their place and you had to put order in this mess, because this is truly a mess, what would you do in one word?
You do understand I'm a professor.
Yeah, but that's why I ask you one word.
Start over. Is that, put it into one
Clean
word.
slate.
Start over.
Start over. From?
From scratch. Can I have more words?
Okay. Yeah, start over. Yeah, clean slate. Imagine create something new, but that's what they're trying to do. Start over. It's.
But you're allowed more than one word.
No, but start over. I'm asking you. Start over from where?
Well,
I'll allow you one sentence.
One sentence. Well, we need international adjudication that is balanced, fair, independent, and respectful of domestic institutions, and that really, whether it's foreign investor rights or responsibilities, probably ideally should be used rarely in the worst cases, the really egregious situations, and not as a substitute for our domestic institutions and our domestic courts. Okay. And it's very unfortunate that ISDS has been taken in that direction by the arbitrators as much as by the treaty
Okay.
drafters. It's a long sentence.
It's a long, very long sentence. But, you know, to boil it down, it's balance and fairness. That's where it all starts. And independence. Okay. I'm turning to my left.
Change track. 2 words.
Yeah, start over again. So switch tracks means...
Change tracks and like move away from giving ever more rights to corporations in all kinds of areas to strengthening the rights, human rights, the rights of workers, and environmental protection.
Okay.
Well, start from the scrap and think about what really what special protection investors really need and why we can't give this protection within working national legal systems. And if we find out that there really is a lack in procedure and not just in substantive law, then think about how to close this gap.
Yeah,
but first, find out what gap we are talking about.
And probably force countries where legal systems are not, that's a little bit the soft power of the EU, force those countries to adopt their legal systems so that actually protects foreign investors. Thank you very much. I hope you enjoyed this discussion. It's not over, but at least we started on the right foot. Can I say that? On the right foot? Let's hope. Thank you. And there is another panel on the alternatives in 15 minutes after a very speedy coffee break. Thank you. So, I hope you had a short break. It was longer than expected, but we're continuing now on the second session on the alternative approaches to regulating investment. We heard in the first panel discussion that actually what I retain really is that we need a balance, a fair and independent process and tool, and we don't know whether the MIC or the MIC, the Multilateral Investment Court, it is the right thing. So here we are now with Natalie Bernasconi Osterwalder, who is head of the Economic Law and Policy Program of the International Institute on Sustainable Development. In this role, she works with developing countries and the government in Africa, Asia, Latin America, in relation to bilateral and regional investment treaty negotiation and investor-state contract. She also leads a project on reforming investment-related dispute settlement. On my left, Mustaqim Degama. He's currently a counselor at the South African Mission in Geneva. He is responsible for intellectual property dispute settlement, TRIPS, and trade-related investment measures and rules related to disciplines such as anti-dumping, countervailing, sexy stuff, countervailing and subsidies. And on my far right, Ambassador Guillaume Long. He is Ambassador of Ecuador to the United Nations in Geneva. He was previously Foreign Minister of Ecuador during the government of President Rafael Correa, and before that, the Minister of Culture, Knowledge, and Human Talent. So, without further ado, I would like, with you and your experience, you all come from Geneva, strangely enough. We heard the UNCITRAL debate, but I don't want to get into that. I would like first to look at, maybe with Natalie first, at what other countries, what road have other countries taken to actually solve the problems caused by ISDS. And as we know, Ecuador and South Africa have taken different roads as well. So we'll look at maybe what's after ISDS, basically. MIC is one thing, but other countries have gone different ways. Please.
I think this session is very much also about more the substance as well as just looking at the process. And we have South Africa and Ecuador here, so I don't want to speak for them, but of course one important step that both countries took in different ways was to terminate or discontinue certain treaties that were no longer in conformity with their constitution or with their development aims. And some also there's to leave ICSID, to leave one of the institutional homes for ISDS. And so those were surely important steps that some countries have taken and in part then replace them with national approaches. But if we take besides these that we will surely look at in more detail with the other speakers, if we take two areas of reform, one on the substance and then the other more on the procedural side, on the substance we can identify four areas of reform. We have reforming investment protection as such. Then we have the introduction of liberalization and how to deal with investment liberalization and addressing some of the risks there. And third, the whole new system bringing in more facilitation, cooperation. This is the Brazilian approach. And fourth, new approaches to the right to regulate, ensuring the right to regulate and protecting the right to regulate, and introducing investor obligations. So these are really the four. And when you look at investment protection as such, there have been approaches to more that relate to tinkering with changing some language and making it more clear, for example, with respect to fair and equitable treatment or most favored nation treatment. And there you have a spectrum of different approaches. So India, for example, doesn't have MFN at all because they had problems with MFN. And they have quite a narrow approach to fair and equitable treatment. Whereas the EU introduced a list of descriptions of what amounts to a violation of fair and equitable treatment, which is still very broad and which still acknowledges the possibility to bring a claim in relation to legitimate expectations of the investor. So there are different, degrees of reform on investment protection, and then also bringing in exceptions clauses and trying to protect the right to regulate. On liberalization, what's interesting, I mean, first of all, the BITs that we have to date, most of them don't have investment liberalization clauses. The old style BITs are very much about investment protection. But the EU, of course, now has combined both investment protection and liberalization after 2009. Before, the EU already had liberalization clauses, but now both are combined. And I think that is a reform in a sense, but of course it's also a problematic reform to some extent. And I think that the EU has recognized some problems with this expansion to liberalization and linking to protection and ISDS, and has in fact carved out the investment liberalization provisions from ISDS. But I think the most important development, or one of the most important developments, was really Brazil. Brazil in 2013 introduced a whole new type of model. So it kind of, and it was able to do that because it had no investment treaties in force. And so they came out with a system that said, we don't want to focus on investment protection and litigation, we want to focus on investment facilitation. How can we work with countries to facilitate trade and investment? And they don't have investor-state dispute settlement. So if there is an issue, for example, with respect to non-discrimination, it would have to be resolved in state to state. And they try to resolve the investor issues that come up through an ombudsman system. So just to say, I mean, this was a break in the sense that Brazil refused to go down the road of the traditional BITs, and it had kind of the possibility to just start anew. I think it could have done even better, but it was a very important reform. And then for the right to regulate and investor obligations, we see very important developments in Southern Africa, in the SADC region, and the Southern African Development Community, where we have investor obligations spelled out in the treaty. And that was an important development. We can see had influence also on the Indian model BIT. So there you do have beginnings of incorporating investor obligations that were spoken about previously. And I think I won't go on, but of course there are then the reforms on process. But I think we talked about that quite a bit.
I would like to ask you immediately, jump on a few questions to you right away, because obviously Brazil started with a clean slate. It is exactly how we ended up our debate previously, with Gus saying we need to start from scratch. Now, with your experience, obviously Brazil started from scratch and came up with a totally different system. When you have thousands of treaties already negotiated, how would you start about to put order in this? Would you start with creating a new structure like the MIC, or would you go more into looking deeply one by one and putting order into one by one. Because it depends on the country, yeah? As you pointed out. In some country, South Africa went more to create investment obligation, put investment obligation in the different treaties. So how would you go about?
Well, I think that it's really about politics. Terminating treaties, there is an issue with signaling a certain political view on the system in a way. And so many countries are afraid of saying we're not investor friendly. And so they're hesitant to discontinue the BITs, because they don't terminate and violate international law. The countries that have terminated was actually in accordance with international law. So it's not like they just broke and violated the law, but just didn't renew the continuation of the treaties. And so I think that if there is no will from the negotiating partner of a BIT to negotiate seriously, renegotiate seriously a new approach that goes both ways for both countries, then the only way is to discontinue, and maybe later on with another government there will be more opportunities to start afresh. But at the same time, I understand that some countries do not want to do it, and there are different ways you could try to approach some of these issues through, binding interpretations and other tools. The reason I think that the EU began with the MIC was because if there was something ripe for reform across all kinds of countries, developing and non-developing, it was the dissatisfaction with the ISDS system, the arbitration system. And so there was it was more ripe in a way to do something about that than there's very little agreement, I think, on the substantive rules. For example, on the one side you have the EU insisting on FET and still having legitimate expectations, and then you have India that doesn't mention fair and equitable and only takes parts of that. How are you really going to come to the same level of understanding there? Also, exhaustion of local remedies that Gus referred to. I think it's also very difficult to find common ground there. The Commission, Canada, US, they're very reluctant to go down that path, but it has been integrated in the Indian model. They have a limited exhaustion of local remedies clause, and also in Southern Africa, they have opted for a requirement to first go to local courts, and only then you can go to the international level. And in Southern Africa, it's state to state at this point.
State to state. Yeah. So I'm turning to South Africa. You had a few problems and decided to take the bull by the horns and find a way to deal with it that is very peculiar. Can you please describe it?
Yes, thank you.
Maybe give a little bit of historical perspective.
Okay, I'll do that. Thank you, Daniela. Good morning, colleagues. I think sitting here and listening to the debate that we've been having this morning is kind of a bit of a deja vu, because I think our story really starts when we become an independent nation, when Nelson Mandela is released. And so at this point, there is this contention, but new government, new rules, and foreign investors feel that their interest may be compromised. And at this point, the government is faced with a dilemma. What do we do to reassure investors that their rights are to be protected? well, we've heard of these bilateral investment treaties. Let's have a look at them. Let's sign them. And of course, at that point, the issue was to reassure the international community that we were able to play ball. We were able to protect investors that were in the market. However, against this context, we also have a very sad history of racial discrimination. And as a result, a very robust constitution placed many obligations on the state to reverse this, including identifying those parts of the population who had been disregarded and actively implementing a legislative program to protect their interest. And this has come out in so-called black economic empowerment programs, affirmative action programs, for instance. And so against this backdrop, when we start doing this, well, we find out that investors are unhappy because, firstly, they never expected that these rules would apply to them. And secondly, they feel that it's unfair for them to contribute to the redistribution of wealth in the country. And so, as a result, we've had a few cases, one which we've lost, another which went the other way. But fundamentally, what this has resulted in for us is that we have an obligation to regulate in the public interest, and we felt that bilateral investment treaties were inhibiting that particular constitutional obligation. On the other hand, if we did this to attract investment, was this a good ploy? Did we attract the investment that we thought we would get? The answer is no. Our experience indicates that we attracted investment from countries with whom we had no investment agreement. And the contrary would also be true, that we attracted very little or no flows from countries where we had bilateral investment treaties. So the issue of the correlation between investment protection and investment flows, in our case, has been borne out to the effect that what we saw was that there was at least, well, if any, a very slight relationship between bilateral investment treaties and, of course, investment flows. A second point that I'd like to make is that once we were challenged publicly, we immediately launched a public consultation process. So for any countries that are in this process, what we did was we said, well, there's a lot of requests to negotiate bilateral investment treaties, but let's suspend those negotiations, enter into a public consultation phase, and the outcome of that public consultation phase was very emphatic. Firstly, that bilateral investment treaties impacted our right to regulate, and as a result, needed to be relooked. It wasn't specific necessarily in what needed to be done, but a year later, our cabinet made a decision that we should terminate bilateral investment treaties, that we should substitute any regime of protection with a national system, and of course, as Natalie said, we've embedded in the system many procedural and also substantive protections, including national treatment. But what we've done was we've also looked at dispute prevention, so the ombudsman system, and ultimately we've tried to accommodate investors in this way. We've also done something very interesting, is to empower a committee of ministers to plot, at least to design a system where we could synergize and integrate a whole government approach. So, and this started moving in the direction of investment facilitation, looking at the business environment, ensuring that when we do implement decisions, that we do it in a way that is wholly sustainable and that is in line with the constitutional imperatives that we have. And so ultimately, this approach we've taken and we've transplanted it into the region, as Natalie very aptly points out. Within the Southern African Development Community, we have an instrument that protects investment, and so we've given further guidance as to what investors can expect, both in terms of their rights and obligations, and in the current phase, we are exporting those particular standards to the African continent as a whole, because we have a Pan-African Investment Code which may inform the basis of broader integration and policy objectives when it comes to the African continent. So it is not just a national perspective that we have here. People complain about international law. They complain about the fragmentation of international law. They complain about investment law. But it should tell us something, that if you don't regulate, if you are not concise, if you are not clear about what you want, other people will do it. And most probably, that person will be sitting in a country that you have no affiliation with and would not have the interest of your citizens at heart. So, in any case, I guess charity starts at home, and so clarity, a point of clarity is really that when you have national and regional systems that work, the impact of international law is not as a primary go-to resource, it is a resource that catches the overflow. That is to say, if things cannot be sorted out on a national or regional basis, that is where international law comes in and is the arbitrator on disputes.
Very clear. Thank you, Mustaqim. I think most interesting part, it seems, that is the fact that you found out that there is no correlation between investment treaties and investment flow, which is one of the elements that pushes countries to negotiate BITs. I'm turning now to Ecuador. You had a different approach, but basically you went about the same route, trying to find a solution yourself without the international, without looking at the international picture. Isn't that?
That's right. Thank you very much for the invitation. Yes, Ecuador terminated 27 bilateral investment treaties at different point in time. First, I would say the easy ones terminate in 2010, mostly with Latin American countries, ones that were ambiguous, that had either been condemned by both sides. And then in 2017, the tough ones, 16 bilateral investment treaties were terminated, a number of them with member states of the European Union. And very much, as my colleague from South Africa has just pointed out, the reasons for this were similar. We found no correlation between the bilateral investment treaties and an increase in foreign direct investment. In fact, this is quite interesting. I mean, as an initial comment, kind of looking at it from a more macro perspective, we think the bilateral investment treaty issue and the ISDS issue in general is quite ideological, really. It's a consequence of this kind of 1980s, 90s neoliberal revolution, which went beyond, let's call it capitalism, in kind of positioning the supremacy of capital over human beings. I'm not even sure capitalism, this is debatable, but you could potentially have a capitalism with the supremacy of human beings over capital, treating human beings as the ends and not as the means. I think the neoliberal revolution clearly thought that the ends of it all was the accumulation of capital, and human beings were just a mechanism in order for greater accumulation of capital. And I think you see that through a number of reforms, and together I think they formed the neoliberal revolution of the 80s and 90s, and I think the bilateral investment treaties are really a part of that sort of fundamentalist ideology. Now, what we found is that investment comes to your country when your country is stable, when there is first of all, for a primary exporter, it's important to try and move away from raw materials and have a more sophisticated and more diversified economy. The more diverse the economy is, the more it's likely to attract foreign investors. In Ecuador, before the arrival to the presidency of Rafael Correa in 2007, the previous decade was marked by 7 presidents in 10 years. Right? So huge political instability, lots of bilateral investment treaties signed and ratified left, right, and center, but a huge political instability, lots of crises, lots of unpaid workers, including civil servants, striking in the street, not exactly the ripe conditions for foreign direct investment to be attracted. So Political stability is an important factor. Of course, creating institutions, which is what I think development is not solely but largely about, creating independent judiciary, and looking at even regulations. We heard this morning, and this is something we often point out, that the European Union is, as a region, one of the greatest recipients of foreign direct investment, and yet it is probably one of the most regulated. The member states are some of the more regulated countries in the world. So this idea that you open up and you have no rules and it's free for all and you attract as many investors as you can, some of them are in there for a quick buck, not necessarily for long-term investment, we think is a myth. And if you have a serious social contract with rules, with obviously incentives, you can't be fundamentalist either way, but with clear rules, an independent judiciary, and political and social stability, and a diversification of the economy so that you don't only get foreign direct investment, as in our case, in raw materials. And what does that mean in the case of Ecuador? Oil. Something like 93% of the country's history of foreign direct investment has been in oil, which, okay, has been welcome and it can be useful in certain conjunctures, but our national oil company could do that investment just as well. So it's not necessarily added value in that sense. We would much rather see foreign direct investment in other fields and other areas. And if you have, if you have these conditions, you're much more likely to attract this kind of long-term investment in a country in order to have national development. Also, in the case of Ecuador, it's very interesting. The country that the people, the country of origin of the people who most invest from abroad into Ecuador. This is a bit of a difficult concept, but it's actually Ecuador itself, because most foreign direct investment is basically Ecuadorians who have dodged taxes in Ecuador, so have hidden their money in tax havens, and then camouflage it as foreign direct investment in order to invest back in Ecuador, and then get all these incentives that the Ecuadorian state gives them, so in order to attract the foreign direct investment in the first place. So there are much greater issues, I think, than the bilateral investment treaty itself, in order for investment to be interesting and in order for development to be possible. Tackling tax justice and tax evasion is certainly one of them, and there are many others. I mean, just very briefly, the way it happened, new constituent process in 2007, 2008. In 2008, our constitution makes extra-regional arbitration unconstitutional. There is then an audit commission that is named in order to analyze this whole ISDS issue. In fact, the president of the Audit Commission, Nekaitisa, is among us today, and she did a great job in order to analyze exactly what were the benefits and the drawbacks and the pros and cons of the bilateral investment treaties. And we discovered no correlation, big problems in arbitration, all sorts of judges who, what's the term in English? Jueces in Spanish? Judges on the settlement disputes, on the settlement courts? Arbitrators, thank you, who had spent a lifetime working as lawyers for the companies themselves and who had very ancestral links with the companies who were now supposed to help us through these arbitration. All sorts of costs that were established. There was a rigorous analysis of the costs and the benefits, and the costs were deemed bigger. And also, I would say, and I would finish my first kind of intervention with that, a kind of bypassing. What ISDS is all about is about bypassing, of course, we've seen this morning, national legislation and national institutions. And I would say international institutions. This is not international law. And this is very important. By bypassing national law, you de facto weaken national institutions. And I've just said I think development is a good deal about strengthening your national institutions, including the judiciary, etc., etc. And so there's an issue of sovereignty, and sovereignty isn't just nationalism and anti-imperialism and there's kind of rhetoric. Sovereignty is also about building sovereign institutions that have to do with rule of law and development and stability. But there's also a second issue, which is the bypassing, the kind of de facto making of global governance at the international level. So it actually weakens multilateralism. I mean, we'll be hopefully talking about this later on in this session, but Ecuador is presiding over the working group, as been discussed this morning, on having a binding treaty on transnational corporations and human rights. Now, it's a tough struggle, but even if we do have a treaty on transnational corporations and human rights, if you have this bypassing of international law and multilateral tools and mechanisms through these kinds of bits, then de facto rules of law, the rules of the game become sort of law, L-O-R-E, becomes law, L-A-W, and multilateralism is inherently weakened in this process. It is interesting, and I think going back to my original ideological point, that a lot of the debate on the binding instrument on human rights and transnational corporations has to do whether we should have a binding one or whether these kind of guiding principles, Ruggies principles, are good enough. Now, can you imagine just turning this around and saying, well, why don't we have a binding instrument, a treaty, international law on transnational corporations' commitment to human rights, and then voluntary, non-binding commitments on behalf of states to respect investors' money, to promise not to raise the minimum wage and not to nationalize their companies. So it is an ideological debate in the sense that the whole terms of the debate have been, it's kind of 180-degree shift to what I think should be inherently the supremacy of human beings over capital, without denying the important role of capital in the market, but the supremacy of human beings.
Very clear, very clear. I think you made your point. And I'm going to ask both of you, actually, because supposedly, from what you say, having a multilateral investment court would actually be welcome, because in a way it reasserts this, it doesn't weaken multilateralism, but actually reasserts multilateralism. Am I understanding you right? But you, precisely, but both of you, would your country buy into an MIC? It's the same question I asked Natalie before. Would it actually, would you go for it if you had a bilateral treatment? Obviously, you're not going for bilateral treaties anymore, it seems, both of your countries, but would you welcome such an institution?
Well, Ecuador is yet to have an official position on this, so I'm going to speak in terms of what my opinion, personal opinion is. I don't have instructions from my ministry yet on this issue, but I'm inherently suspicious. I think it can be either much better or significantly worse, and it will depend a lot on the details or the finer tuning of what it's about. If it's to kind of give a clean face and legitimize ISDS, then obviously we would be very suspicious, and we think ISDS in general is, as I've just argued, is problematic, highly ideological, and I think historians 100 years from now will look back on it as a sad phase in our history. But the problem right now is not, it's not an issue really for Ecuador, because Ecuador's constitution expressly prohibits arbitration in extra-regional settings, in extra-regional courts, in extra-regional instances. Ecuador's proposal, unfortunately, this has stalled over the last few months and years, and we hope to be able to bring it back to the fore along with our neighbors, is to have some kind of mechanism. This is not yet clear exactly what it would entail, but some kind of investor-state mechanism at the UNASUR level. So the Union of South American Nations, which is this integration body which we're trying to create since 2008 with 12 countries, the 12 countries of South America. But our constitution is very explicit in that sense. We could not have arbitration courts outside of our region.
Mr. Kim?
Yes, thank you. I think it's it's a question that I can answer in a very direct way. I think the time to set up new institutions has gone. We have to use what we have. We have to optimize the institutions that we have, both on a national and on an international level. Now, having said this, South Africa has also been at the forefront of trying to understand the debate in respect of specifically adjudication and dispute settlement. And of course, one of the main arguments that has been made in respect of the MIC is the so-called transparency, stability, and predictability that it brings to an otherwise failing system. Well, we would tend to disagree for various reasons, because we believe that we've lost a decade where we could have done this. When we started, and I think the point that Gus makes quite eloquently, when we started to look at the UNCITRAL arbitration rules, which had last been, which had been operationalized in 1978, when we started looking at reforming that process, part of a group of countries' proposal was that we also at that time incorporate transparency issues and we make it applicable to all bilateral investment treaties or IIAs. And this was vehemently opposed in the United Nations and through the processes that were conducted, and I think as Gus indicates, we have an outcome that is suboptimal. But if we had acted at that particular moment, we would have been able to address not only all of the bilateral investment treaties, but if governments were courageous enough to go through with their commitments, we would have been able to address at least 1/3 of the current investment stock, because all of them became due either for cancellation or renewal at that time. So we missed a critical window of opportunity to really get a global consensus and a buy-in. Now, going forward, is a court going to be the answer? No, because it just creates an alternative form or avenue of justice, an alternative track, as Pia said. Also, we have no opportunity to integrate substantive law. Where does law exist? Law does not exist in a law chamber. It exists wherever you find it, and it is binding in jurisdictions, in national jurisdictions. So we have to understand which law will be applicable. We don't have consensus in how we reform this. The failed talks on a multilateral instrument is a very good example. And so when the issue of ambition comes up, it is not for a lack of ambition that the European Commission has chosen this procedural aspect or approach to the instrument. They know very well that there is no consensus on a substantive outcome. Sitting at, and this is how we bring in the Geneva aspect here, sitting in Geneva, there is currently a tumultuous debate about how we incorporate investment rules without calling them investment rules. We call them investment facilitation. And these are predicated on transparency disciplines. But in the World Trade Organization, we have a huge body of decisions that already indicate how even transparency may impact on the right to regulate and how invasive this is. So investment is necessarily a contentious point and something I think that needs perhaps further thought. But coming back to such an institution, I do not think that we can support such an institution at this point, firstly because of a lack of clarity, but also, given our experiences, we don't believe that such a system will add value to the current setup.
Okay, well, pretty clear. I'm going to turn to the room right now, a little bit earlier than I did with the previous panel, since there were quite a number of questions at the time. Anyone is actually triggered by this debate on the alternatives that would like to ask a question, Otherwise, I'll continue myself. Anyone? I see 1 and 2. Are you asking? 2, 3. Okay, please.
From both ends. I was wondering what your view is on the problems to terminate investment treaties. Like, for example, Indonesia is a member of ASEAN. They have their own agreement. Then ASEAN has made agreement with other countries. So it is de facto very difficult, you know, to get out. And if you have, for example, an investment chapter in a treaty, as Gus has said, there's a problem to terminate this. So what are your views? What kind of reform would be needed to, you know, to resolve this problem? To terminate you, to get out of a system, you know, previous governments have been signed up to. And related to this, if I'm looking at the mandate which was given to UNCITRAL, this was a very broad one to look in how far UNCITRAL could play a positive role on the global reform. We now see that in Europe the discussion is totally dominated on the question for a mandate to discuss a Multilateral Investment Court. But the UNCITRAL mandate, as I understood it, was broader. So it would be helpful maybe if some people could share with us, you know, what beyond MIC Multilateral Investment Court could be something, or where there needs to discuss at UNCITRAL. Thank you.
Yeah. Actually, it's a very interesting question. The UNCITRAL, the MIC, it's as mind-boggling exercise. Over there.
So I've got a question for Natalie, which is, in your view, what contributions? Sorry.
Could you introduce yourself?
Oh, sorry. Apologies. Yeah, my name is Fabian Flüß. I work at Friends of the Earth Europe here in Brussels. So my question to Natalie is, in your view, what contributions do investment treaties make at the moment to sustainable development, positive or negative? And to Guillaume and Mustaqim, I wanted to know if you compare what you were told before you terminated your investment treaties of the consequences and what actually happened after you terminated them. Do these predictions, did they become true, or what was your experience with that?
Thank you. The lady next to you, yeah.
Yeah, my question is directed to from the representative from Ecuador and South Africa. My name is Dorothy Guerrero. I'm with the Global Justice Now in the UK, but I'm originally from the Philippines. And when I still look at issue, I still look at it with a Southern perspective. And what I notice in this all long years where developing countries are negotiating bilateral treaties, free trade agreements, multilateral treaties, is that with these new courts, shouldn't it be the time for developing countries to wake up that we're really losing out in this? We've been losing case after case in all these in this arbitration courts, and whether we lose or not, we pay dearly for it. We pay dearly with taxpayers' money, hard-earned money of our poor citizens. And then secondly, on the, it's not just when you mention the issue of sovereignty, another important factor there is flexibility, because what we are losing here also is the flexibility to answer to the new trends of like climate change or the impact of the negative impacts of neoliberal policies that was taken by previous governments and have produced a lot of injustices and poverty. So supporting this mechanism is actually tantamount to working against developing country interests. So what is the problem with not taking national interest here? And my last point is that in terms of competition, of course, no country would want to present itself as anti-foreign investment, but shouldn't it also be maybe a competition for countries to protect labor, to protect the environment, to promote sustainable development or sustainable rural development especially? Thank you.
Thank you. Yeah, basically competition for countries to come into into other countries with greater responsibility and obligations. Who would like to answer maybe on terminating the BITs? I think and then the UNCITRAL MIC conundrum.
Okay, in terms of the question that was posed, what is our experience on termination of our bilateral investment treaties? Well, you know, when we terminated it, many people predicted that we would fall off the face of the earth, that we would not get a single investor to come to the country. And I think 8 years later, 9 years, well, 7, 8 years later, we are still on top of the index for attracting investment into Africa. At the time when we terminated our bilateral investment treaties, investors did not say, well, guys, don't terminate these things. They said, well, if you have to terminate and if you have to regulate, we have no objection against that. But when you do regulate, give us clarity. Be specific in terms of what you're expecting from us. So ultimately, when we terminated these agreements, there were no consequences in terms of investment flows. And we did so in the midst of a financial crisis. 2008, 2009, we saw a big regression in terms of our GDP, but this was because of structural global problems. And even during that time, if you look at the World Investment Report 2014, 2015, 2016, even 2017, you will find that South Africa has still been attracting quite a lot of investment. And of course, we're taking this further. You know, we're improving our investment climate, and we're implementing programs to really focus the types of investments that we want. I think, as Guillaume appropriately indicated, if you don't plan to attract good investment, you will attract only bad investment. And what is bad investment? Well, bad investment is investment that does not make a contribution to your economy. So if you have structures in your economy that is prone to attract only portfolio flows, well, portfolio flows in themselves are not bad, but as a structural indicator, these may contribute to fluctuations in your economic performance. So try to address them, try to move up the value chain, and so forth. So I think from that perspective, we have not, from a financial perspective, had any backlash. And I think also from an institutional perspective, we've been strengthened. And we've taken a leadership role in the debate in showcasing that we've actually done it. We've terminated our bilateral treaties, and we've replaced it with something even fairer. Because in what system would the treatment of an investor be dependent on whether the country had a bilateral treaty or not? Our Investment Act treats all investors the same, irrespective of where they come from, irrespective of whether there is a bilateral investment treaty or not.
Did you change your courts or your jurisdiction to actually adapt to the fact that there is no bilateral, and probably I'll ask the same question.
Yeah. We do not. I think part of the upscaling of the Multilateral Investment Court debate is really, well, traditionally, the reason why you had bilateral investment treaties was to ensure that when your investor goes into a jurisdiction of weak governance, that they are not subject to injustices where, for instance, the judicial system is suboptimal, aspects of the rule of law would be incomplete. However, traditionally, developed countries have not entered into so-called bilateral investment treaties with one another. This is a recent phenomenon. So these countries traditionally are said to have good institutions, rule of law, independent judicial bodies that are able to make objective decisions. And so upscaling it to even include developed countries is quite an interesting development. So traditionally, the reason why you had BITS was really to look at weak governance, but that is not the reason anymore. And so ultimately, we did not need to upscale our judiciary because we have a strong, fierce, independent judiciary. Even highly political and sensitive matters are dealt with the judiciary in a very competent way. So ultimately, I think that is par for the course. And of course, what Guillaume also mentioned was that if you have, or at least if you have the hope to develop good public institutions, you cannot afford a subversion of domestic processes. That is to say, do not starve your institutions of the experience of managing certain types of matters. Do not starve your courts of the experience of managing and adjudicating investment disputes. And that is the whole perspective, that ultimately, if you want well-functioning institutions, the processes should necessarily be anchored at a domestic level. No international arbitral tribunal will be able to give you the relief that a strong domestic independent court would be able to give. A good example in international arbitration law is, can an arbitrator make a ruling on interim measures? And the answer is, it's very difficult for a third party sitting in a country that has no relationship with the country at stake to make these rulings. The most effective institution to do so is a domestic court, because if you want a preservation measure, you can get a preservation measure in a domestic court.
Clear. Guillaume?
There were questions on what are the problems with terminating investment treaties. Well, there are numerous problems, but I would say they're mostly political. I mean, it took us a while. The Constitution ordered us pretty much to get out of bilateral investment treaties in 2008, and the real tough bits were finally terminated in 2017. So that's 9 years of a lot of lobbying, including inside the government with different, you can imagine what these kinds of things entail. I've already said, I think that we'll see. I mean, obviously, the latest series of termination of bids are too recent still to gauge their impact. But I really think that there is also a global growing. I mean, the reason why we're here, there is a growing consensus that this has to come to an end. Inside the European Union, there's a huge debate about how what I mentioned before, this kind of creating de facto rules that actually go against real laws, both domestic and international. In the European Union, you've got countries being condemned in arbitration for having upheld European norms. So, you've got this kind of parallel de facto, de jure system, which we think is not sustainable. And I think the reason why South Africa, Ecuador, but there's this debate here in the European Union. Brazil is another case. India is another case last year that we have to look at closely. I think you will see a growing move away from this. And with that growing global consensus, hopefully less and less political pressures, less and less lobby, and countries will be quicker than we were, because it took us a while to condemn, to terminate the investment treaties. It is striking that this is a case where you can go immediately to arbitration instances without exhausting the resources that you have at your local judicial legal level. In human rights law, in the Inter-American system, for example, there is an Inter-American Court of Human Rights. In order for anybody to go to the court and take the state to court for violation or abuse of human rights, you need to have demonstrated that you've exhausted all recourse in your domestic polity, in your country. Otherwise, the Inter-American Court will not treat your case. And yet, in investment, and there are a field of investment, bilateral investment treaties and ISDS, you can go straight to these instances. I think, once again, that shows what the kind of priorities have been, and we really hope that this can come to an end. This is one of the reasons why Ecuador and South Africa have been pushing for this binding instrument on human rights and transnational corporations, which is obviously what we think should be the big priority right now.
There was a question about developing countries taking more of a stance at the international level to push for a different kind of...
Sure, I mean, there is a big issue about global south versus global north. We try not to make it too much about that because we think, as this morning's debate has shown, it's becoming north-north, south-south, it's becoming much more complex. I think there is obviously always a greater issue with developing countries because they face more urgencies, they're more vulnerable institutionally as well, so they can fall prey to nasty investors more easily than countries that have a greater institutional capacity. But yes, I think it's clear that more developing countries have to understand that that's not the way to attract investment. And they also should understand that countries never win. States never win. Sometimes they don't lose, but that's not the same, right? So very rarely, in fact, they don't lose. So the company takes you to the arbitration mechanism, and sometimes you don't lose. But the other way around, I mean, there are experts here, and I see Gus at the back here probably knows much more about this than I do, but in my knowledge, there are very, very few cases when states have taken companies to arbitration mechanisms. It's always almost systematically the other way around. So if you're lucky, you don't lose, but you can't really ever win. And I think that global consciousness has to grow, and certainly in the global south and in the developing world.
Natalie, I'm turning to you now. Obviously, you don't have a direct knowledge of your country. You have not been, but you have studied this inside out. So on the termination systems, would you know of any other countries that had really difficulties that were insurmountable, that had to give up?
Well, first of all, I think that today to terminate is politically easier than it was when South Africa took the first step. So for sure, there is so much questioning about many elements of the investment treaty system that, announcing that you're not going to continue with the existing BITs would be politically less sensitive. But at the same time, working with many developing countries, many are still afraid, and they don't want to take that step. And perhaps that's why UNCTAD, I think in 2 weeks, will focus precisely on what they call phase 2 of reform, which is what do you do with the existing BITs? And so definitely we have 2 countries here that took the step to terminate, and there are others out there. We all know them, and they've been mentioned. Some are doing it quietly, more quietly, or at least have taken the decision not to negotiate new agreements, which is also important because there are still countries that are negotiating new agreements, and not always are those new agreements more modern than the very old ones. In fact, they might be the old investment protection model plus liberalization. So it's not that clear cut. And for those countries that are more hesitant, there have to be ways still to find some way to reduce the risk that they face. And I think that there are a lot of studies out there now, and more in the making, looking not only at the risks of the claims that we know about and the claims that are brought, but all the phase before a threat that a claim will be made if certain actions aren't taken, for example, granting of a permit, or just the regulatory factor when you regulate or even legislate, that there are always thoughts about, could I be sued if I do this or that? And that can be limiting as well. And in fact, Gus has published on this with some, based on interviews he conducted with policymakers. So this is an important issue, and it will continue. So for those countries that do not feel that they can take the step to discontinue the existing bits, we have to find some other solutions for them. And I mentioned, I mean, there are possibilities to use interpretation, and moving away from the traditional arbitration is also an option that they have to consider. Which brings us back to the MIC, and we can come back to that.
Yeah, we can come back. There was a question, I want to stay with you, on which reform steps do you find particularly useful from this perspective of sustainable development? I think there was a question there.
Right. Well, first of all, I think the question was more whether also the agreements that we have today, whether they contribute to sustainable development. And I think the first question there is, why were these treaties signed? They were signed to attract investment. And right now there are studies coming out that actually analyze all the economic studies that have been made that say, well, there is no conclusive evidence that there is any link between investment flows and investment protection treaties. We have evidence from these countries that are here today with Ecuador and South Africa, but the new studies actually show that it goes beyond that really look empirically at this issue, that we cannot see that link. So the first thing is, if there is no link, then we have no increased investment. Now, assuming we did have more investment, then the question is it sustainable investment? And what I would see a treaty try to do, if you want to put it in a treaty, is to have more cooperation to ensure that investment flows are there to support sustainable development and are really geared at addressing the sustainable development goals and advancing them. So right now, there's no qualification on what type of investment. There's nothing on the quality of investment. So there we already also have a limitation. What it is clear, though, is that every host state carries a risk. So maybe we have some uncertainty on the flows and quality investment flows, but what is certain is that you will really be running a great risk when you sign the treaties, and that we know. So what is happening in the treaties to address the risk and some of the negative policy space effects and limitations is that you put in sustainable development elements that are really about limiting that risk. So first you accept the risk, and then when we hear there are more and more sustainable development elements in the treaties, it's just about trying to deal with that risk. But it's not really about positively trying to promote sustainable investment or investment for sustainable development.
Okay. Now, I would like, but there was a question about the MIC and UNCITRAL that I would like to get out of the way, because the two processes could be conflictual to one another. So what is your view how to reconcile maybe the two, if there is a way of reconciling or not reconciling? What is the perception in Geneva also on the MIC.
Well, this is not.
I mean,
Geneva is rather marginal to the discussion.
No,
about
but
the MIC.
you understand what I mean,
But I
right?
think, yeah, I mean, again, I think from Ecuador's standpoint, it's a no-no for now because of our constitution, which is the biggest factor. And again, we'd be very careful. Yeah. And right now, our priority is essentially making sure that if there is a mechanism protecting investors, which we're not against, especially if it's going to be fair and it's going to work and it's going to actually, there is going to be a correlation between that mechanism and investment, which there hasn't been with the other mechanisms and investment. And we've said that publicly. There also has to be a commitment at the multilateral level that transnational corporations and other business enterprises will be accountable for human rights. I think those things for us are inseparable, and I don't see us making any move in Vienna or anywhere else without that being directly going together. Yeah.
Well, I think in Geneva the the dialogue is very interesting because it kind of reflects the status quo that we have. When the Commission first circulated this proposal, it was brought to the WTO, and of course, one seminal debate that we always have is to what extent does the WTO cover investment disciplines? Now, of course, some of us will know that, yes, investment is covered in various agreements under the Marrakesh Treaty. So trade-related issues are covered, but more directly, investment in Mode 3 under the GATS is covered. And so we have a lot of experience in the litigation and the debate about the mandate. And one of them is that as soon as you start talking about investment liberalization, liberalization pushes into the eminent domain, into what is the national domain, and the right to regulate. In WTO speak, we talk about domestic regulation. And if you look at the problems around domestic regulation and what states are able to do to either discipline or to require service providers that set up in their territory, it's an inevitable debate that leads us further from where we need to be. So bringing it back to the Multilateral Investment Court, we've been very clear in our statements that we oppose this idea because it does not address the fundamental disconnect in respect of the substance of what applies to investment. Also, we have participated in the UNCITRAL process, as I indicated in the earlier years. And of course, this process is more general. It does not necessarily deal with the Multilateral Investment Court in its entirety. It may deal with some of the issues, but it does not deal with all of it. And so one suspicion, at least that has to be allayed, is that the current UNCITRAL process should not be hijacked to make it only about a Multilateral Investment Court. We accept and we welcome any constructive debate on how we can make the system work better. Now, I've also perhaps should be clear that when it comes to international arbitration, whether it be of the ilk of investment arbitration or commercial arbitration, we have to make a fundamental distinction between private goods and public goods. When a state acts in its capacity as a procurer of a private good, all good and well. This is a commercial situation. But when a state acts in its capacity as government and deals with a public good, whether it be education, whether it be health, whether it be the environment, there are different considerations to take into account. And as a result, these matters are ill-fitted to be adjudicated by private tribunals. And as a result, this is one of the consequences of having seen how things can go wrong. So ultimately, the Multilateral Investment Court is perhaps a stillborn idea, something that does not add value. What is the value that this court will add to the situation that we already have? If it doesn't give us direct solutions, then, well, we should focus on what we have and try to improve that over time. If it doesn't have any impact, well, then we have to treat it as it is and discard it. And so unless we hear any better ideas, any more concrete and firm ideas from the European Commission, I don't think that we can support it at any level. We've been clear at the G20 level, we've been clear at the BRICS level, we've been clear whenever we've spoken on this.
Crystal clear. Would you like to? Yeah.
On the. Well, first of all, I think that the issue of the MIC is linked to the fear also of expansion of investor-state dispute settlement, because there are really two scenarios. One is the expansion to areas which is happening under the CETA, for example, to introduce ISDS, whether it's arbitration or a court, ISDS, still ISDS, into relationships between countries that have well-functioning legal systems, where previously you do not have ISDS. And that is the other side, the expansion side, but at the same time you have these 3,300 treaties, most of which have ISDS. And the problem is that we're not starting from scratch like we would have liked to in the last session, and I would like to start from scratch. But the MIC discussion comes up in a context where you have a system that's quite flawed and is now under attack. And so the question is, in those situations, is it not better to have something better? So on the one side, the fear of expansion, but on the other side, we can't ignore that there are all these cases that will be brought under existing BITs, and they will go to investment arbitration. So I can tell you that the arbitrators and the law firms, they don't want the MIC to ever see the light of day, because it's more convenient for them to continue with the current system. So I think that those two things have to be distinguished. In addition, I would say the only way I think that the MIC really has and could be appealing to critics of ISDS, or even countries that are exiting this ISDS system, is if it is broader, like the mandate would allow it to be, so that you can bring in some of the issues that Gus spoke about this morning. And if you have ISDS there under treaties, but it shouldn't only be that. In fact, and I know that many of you in the room don't agree, but ultimately it could also be used as a system that's already up for the binding treaty that is being discussed. Because part of the issue will be in the binding treaty, you determine the obligations that will be brought under that treaty and defined under the treaty, but you still will have to set up a mechanism for enforcement, and perhaps it's better to actually think about a system that is about addressing issues that arise under transnational or large investments, and they raise different issues. So if you have a tribunal or a court that only looks at issues brought by investors, it's going to be a lopsided court. It should be able to hear different views.
So basically, if we're going towards MIC, let's have it much broader than the current mandate makes us think it will be. I'm going to now, I've seen a few hands come up right here. Was it 1, 2, 3? We'll take another round of questions and then maybe we'll come to a close. Please.
Thank you. Leila Hughes from the Center for International Environmental Law, and it's actually, this is a question for the ambassador from Ecuador, following directly on what Natalie just said. So it's clear that Ecuador opposes the investment protections without obligations, and that it's unlikely that Ecuador will be able to support the EU's proposal for a MIC at UNCITRAL, but that the mandate for the discussions at UNCITRAL are much broader. So what do you think is the possibility for the negotiations at UNCITRAL to lead to the creation of a mechanism with unbiased judges that would consider not only investment privileges, but also obligations, and would allow people as well as investors to bring a claim?
Okay, before answering, we'll take the three of them. Please. Yes? No, I don't think it works.
Just press the button.
Right.
Oh, sorry. The first time I'm in this room. My name is André van Walter. I work for the European Commission. I would just like to very briefly try to give a short reply to Mr. de Gama. And I have one question for Ambassador Long, because Mr. de Gama, you were asking what the added value would be of a MIC, and just to back exactly what Natalie was saying, our approach here is really an approach of replacement. We have a responsibility for 1,200 EU bilateral investment treaties in force. There are over 3,000 worldwide treaties, and what we intend to do is to replace the dispute settlement provision of these treaties by something that is better, more legitimate, more fair, more transparent. This is our approach, and if we do not do this, we have now two distinguished representatives of two countries who have denounced BATs. I personally do not believe that many of these 3,000 treaties will be denounced in the next years. And my belief is that if we cannot move forward with the reform that we are proposing, the result will be the status quo of today with these thousands of treaties, these private arbitrations. And I do not think that this is in the interest of participants in this roundtable. So just to reply, this is how we see the added value of this project. And my question to Ambassador Long was, you referred to the UNASUR process of creating a regional center for international investment dispute settlement or investment arbitration, which I understand has been driven by Ecuador in the past and that you still support. My question would be, why regional and why not global? You may know, for example, the initiative for the Multilateral Investment Court has been initially driven by the EU and by Canada, and we have then taken the deliberate decision to bring this to the United Nations system in order to have a fully inclusive process where all member states of the United Nations can express their views and participate. So my question to you, Mr. Ambassador, would be why do you believe it would be better to work on these kind of investment courts at a regional level? Why not rather have the debate in the United Nations system? Thank you.
Clear. There was another question. Yeah.
Hi. Just a quick question on the drawing on the first question, actually, about the possibility to use the MIC or another mechanism to enforce both investors' rights and human rights. That's a debate that we see maybe coming at some point in the future when joining those two debates about the UN binding treaty and the MIC. And so more specifically, is UNCITRAL, you think, the good area to discuss this when we know that it's crowded with mostly lawyers and specifically investment lawyers? So that's one. And two, maybe a more general question, or if you have comments on what has just been said as presenting the MIC as something that will replace ISDS in existing treaty, whilst we hear and we heard many times the Commission using the perspective of a MIC to justify adopting CETA, JEFTA, the treaty with Vietnam, etc. So actually not pushing forward this agenda to replace ISDS, but to justify new treaties.
Who wants to start? Maybe there were two questions addressed straight to you, so you maybe You want to answer to the Commission?
I just, and I mean, I'll stand down. I think it's very good that the Commission, responds to some of the things that has been said. Now, of course, and perhaps you could give me a more direct answer. It's very good to know that the Commission intends to replace these treaties at some point in time. Now, firstly, when is this going to happen? And secondly, when we look at the treaty-making practice of the European Union and the latest policy overview that has been given by the Chief of the Commission in respect of exporting European rules and regulations, I want to know, so when entering into free trade agreements, is it possible for us to already start to address the backlog that we have? That is to say, make the treaties specific, basically indicating that they will apply only to future aspects, reiterate that either existing treaties will either be cancelled in some way or another or will be terminated at some given point. Now, if we can do that, if we can reach a point where we say, yes, we agree that the existing stock of treaties are not optimal and that we should terminate them, that we should also be able to work together to replace them in a more sustainable way. This is the things that we want to hear. This is the thing that builds good faith. Because ultimately, I challenge the European Union, I challenge the Commission to convene a multilateral forum for a more robust discussion, not only on investment adjudication and procedures, but more fundamentally how we manage the next phase of globalization. For many years, we have said, well, free trade is not free. It comes at great cost. And as a result, we need to be careful how we enter into these negotiations. As the developing world, we've said, well, free trade has destroyed our economies. And for a long time, people told us, what are you talking about? You now have products on your shelves that you didn't have there before. But at whose expense? At our local producers' expense. And ultimately, it is the safety net and it is this redistribution of benefits. And this is really the question. When the European Commission and the competition and antitrust authorities make a ruling against Google, asking them to account for their tax obligations in the European Union, this is not a question that is limited to the EU. All of us have the same questions. And so coming back to what Guillaume says, our interests are converging in fundamental ways. Our interest is located in a global common that affects all of us, equally or unequally, depending on where we are in our stages of development. So coming back to this issue, yes, we can go along with clear messages by the Commission. We take note of what you've said. But, I think the devil is in the detail. It is what is to come and actually actions that speak louder than words in how we address the underlying issues and how we take those issues forward in a more common and balanced debate. And I appreciate, the comments that you made, but, there's still many more questions that we need answers to. But of course, it's something that we integrate in this approach.
Maybe the dialogue can start. Guillaume, I guess you get it. That's the dialogue. Yeah.
The problem with this is that we always go back to the origins and the causes of the conversation. I don't want to go too far back, but there's, there is kind of an issue with do as we say, not as we do, and as we did in order to develop, which is what the fundamental dialectic exercise in global politics is often about. Most serious historians will claim, I think, that the developing world developed through highly protectionist measures and not through free trade at all. And when they suddenly have a position of dominance in the global market, they change their tune and they say, no, 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 look, free trade is great. And it happens to everybody. It happened in the 19th century with a number of European states. It happened in the early 20th century with the United States, probably. It's a great example. And it happened in the late 20th century and now with some East Asian countries. So the position of dominance in the economy conditions your tune as to whether trade should be free, not so free, maybe very free, maybe, yeah. So this is an issue we have. We have it respectfully. We engage with all our partners. But we always try and insist on, this do as we say and not as we do, because there are still a lot of subsidies. And as we did, more importantly, is kind of at the heart of all this issue. And it also has to do with the international rules of trade and the international rules of investment. Now, I wish I was still an academic in order to be able to answer some of the questions, particularly on the UNCITRAL question, but I'm the representative of a state. And the state right now is deciding on its position on not just the MIC issue, but as I said, which right now is a no-no because of constitutional reasons, but on the other aspects of the UNCITRAL negotiations. So I won't comment on that. I will comment on the UNASUR issue. And this is not, as you said, me that believes this. It's the Ecuadorian people who ratified the Ecuadorian constitution in a referendum with 65% of the vote. So they ratified this instrument, which is the maximum legal charter of the Ecuadorian state, which stipulates that you cannot have extra-regional forms of arbitration in investor-state disputes. Now, the constitution is, I think, a fantastic constitution, a wonderful document. It can be reformed, but it's something that's not taken lightly. And so far, this is the document that stands. Now, that allows us to move within spheres such as UNASUR, which is kind of equivalent. I don't like that parallel too much, but it's the kind of equivalent of what Europe created in this wonderful process in the 40s and 50s and tried to create this integration. And so this is right now what we are committed to. Now, I do think that there are a number of ways in which our position and the European Union's position is getting closer and closer as opposed to further and further away. I think we're seeing it in the bilateral investment treaty debate. I think Europe itself is waking up to a number of things. I mean, for European countries to have to go to ICSID to deal with their European problems is, I think, problematic, and I think a number of Europeans have come to terms with that. The fact that they've come to terms with the fact that their legislation often contradicts bits, and on the human rights issue as well. Yesterday I met the European delegation in Geneva, and from not wanting to be in the first session on the binding treaty, we've gone to them attending the second session on the binding treaty, and now I think there's a commitment to start discussing the substantive issues of the binding treaty regarding transnational cooperation and human rights. So I mean, this is a debate and we should be forthright in our ideas, but I think there are a number of things where we can agree and try and change the world for the better and not have these double standards in terms of how we treat human beings and how we treat capital. There are, of course, a number of instances. Sometimes say, yes, but international law is just for states, it's not for non-state actors. But there are a number of instances where terrible dictators can be taken to court. But there are none where states can take court big money, right? And that says a lot about, I think, the world in which we live in. If big corporations violate human rights, there are absolutely no consequences. It's just nasty state actors. No? The state is the enemy. And of course, states can and have done historically violated human rights. The history of the 20th century, I think, is a sad tribute to that. But as we have more and more power being redistributed from state actors to non-state actors, particularly corporations, and that's certainly one of the big historical processes that's underway in the late 20th century and early 21st century, we have to adapt international law to these new parameters, and we need to have transnational corporations and big capital accountable to human rights too.
Okay, thank you. Natalie, do you want to react? Do you want to react? Well, there have been a lot of...
there have been a lot of interventions. So
no, but it's mostly on the basics of this debate, which is, you know, the redistribution of the benefits of globalization and where we have gone wrong in it, and probably one, it was allowing the investors to have a separate jurisdiction under which they would, you know, wreak havoc on many elements in trade and investment. So maybe having last words from, you know, obviously their state. You are an independent scholar on this. The last word.
Yeah, there are a few questions that were raised. First of all, just very briefly on the issue of UNCITRAL. It's true that ISD was quite involved in the past discussions in UNCITRAL about transparency. And it's true that I was quite astonished of the very wide representation of arbitrators and private practitioners sitting for the governments. So it is, and it's supposed to be an expert body, so it's not typical for these expert bodies to actually negotiate treaties. So this is, I think, more about having a discussion about what an international system would look like. And it can only be adequate if countries, especially also developing countries, if they send people from their governments. It's very important. And I think that that is something that EU members and the EU kept saying in July when they intervened. They said, we need government representation. And so I think that you know, that will be the test whether it's the adequate body or not. If governments really are represented by government officials, and I think in this case they really should be, then it'll be a different situation than if they continue to be represented by arbitrators and private practitioners. So that's sort of that process. And on the issues and the distribution of benefits, and I think that it was very well said by both speakers. And Mustaqim said, you know, there may be a convergence also on these issues. And I would hope that. And I think in the rhetoric and in the politics that we hear, we can really see some convergence. But when you look at the text of the EU agreements that are circulated, that are officially public or not officially can be accessed, they really show that there is still very little there's very little to promote or allow space for development. So there's quite a bit of attention paid to issues like environment or health, but very little to the right to develop. In fact, there are a lot of provisions that do the opposite. And those are pretty visible, for example, in the prohibition on performance requirements. And seeing those don't really make me think there is that much convergence. I think that the development angle has to be better understood, especially as we see we're not on a level playing field. And there are countries that really need to use industrial policy tools that are being constrained through these agreements, and not only through existing ones, but also the ones that are being negotiated today. So, and on if you look at, for example, the sustainable development chapters of the EU agreements, there's so much more that could be done there. Really looking at the behavior of the investors, because ultimately, if we want sustainable and quality investment, it will also depend on the behavior of the investor once they are in the country. And these agreements right now really don't support or the systems that are already out there. The laws are there, the treaties are there, but these treaties the investment treaties and trade agreements should be used to support what we already have. So for example, you could put into place accountability mechanisms through these sustainable development chapters to be able to allow individuals to bring complaints and have an investigation of what is actually happening on the ground. So I think that there's a lot that could be done that hasn't been done yet. Thank you.
I think on those words we'll probably end. I think it's a lot of food for thought for the Commission. I think it's not a clear-cut answer to how you solve the ISDS problems. It probably goes wider and wider. When I look at, I'm a generalist, so when I look at what the Commission is trying to do to solve the problems of migration, for example, the refugees coming from Africa, and when you're talking about development and sustainable development, helping those countries to develop further so that they don't have, we don't have all the economic migrants coming to our shores, it probably starts with trade and investment in those countries. So I will end it here. Thank you so much. I think we have still a full room for having been so loyal, despite the delay. Thank you to our panelists and our previous panelists as well. I see them in the room. Thank you all. I think it was a very interesting debate, and I hope it will continue, because obviously it's craving for it. Thank you. Bye-bye.
Scary because it is also scary because I think the binding treaty is advancing well, and that could be a way of stalling.